Well, with an expectant hush like that, I think we'll get underway. My name's Pip Nicholson and I'm the Dean of the Law School. We meet tonight on the land of the Wurundjeri people of the Kulin Nation, and I pay my respects to their elders past and present, and indeed pay my respects also to any Indigenous peoples in the room. Good evening and welcome to you one and all, and congratulations for making the trip up on what is a particularly cool Melbourne evening. I would like to acknowledge King and Wood Mallisons, who have generously supported Dr. Hagan's visit to Melbourne, and the Melbourne Social Equity Institute for co-hosting tonight's event. I'd also like to acknowledge my colleague Gary Cazalet, who has been a participant in the Stanford Design School and indeed was instrumental in reaching out to Dr. Margaret Hagan and inviting her to visit with us at Melbourne. So thank you, Gary. Let's talk a little bit, albeit briefly, about tonight's lecture on human-centred design for legal help, which will indeed be delivered by Dr. Margaret Hagan, Director of the Legal Design Lab and lecturer at Stanford Institute of Design, more commonly known as the D School. We are fortunate indeed to be able to welcome Dr. Hagan to the Melbourne Law School, where she will be involved in a series of events that unfold across the week. It's part of our ongoing, and I think I can proudly say escalating, focus on the challenges of technology and innovation and our ongoing commitment to access to justice. Dr. Hagan will teach in Gary Cazalet's Law Apps class later in the week. It's a class where students design apps to enable access to justice, a subject we've been running for a couple of years. She will also deliver a workshop to staff tomorrow at lunchtime and then be hosting a half-day Access to Justice Innovation Workshop where the Law School's working in conjunction with the Legal Services Board. And in that particular workshop, Dr. Hagan will work with the attendees to identify how the legal community, largely in Melbourne, but also working across the state, can use human-centred legal design methodology and consider how new technology can improve services or policies that might better serve the Victorian and Australian public. In conversation with Margaret yesterday afternoon, we talked about some of the ways in which many of the challenges that are unfolding for us in terms of access to justice issues in Australia are replicated across the world. I was in India last week and I was being introduced to new dispute resolution methodologies which laid wide open the possibilities for comparative research about how e-consumer-based transactions could be comparatively viewed for their processes and their outcomes in jurisdictions as diverse, for example, as India, Melbourne, Victoria, East Coast of the US, West Coast of the US, and across the globe. Our own focus on technology and innovation at the Law School continues, and I also wanted to make mention tonight of the recently established Digital Citizens Research Network, which brings together academics across the Law School researching in the field to consider the ways in which citizens in the state, in particular, need to design for and respond to digital disruption. We're looking forward very much as a law school, but also as members from within the Digital Citizens Research Network to Dr. Hagan's expertise in this area, which she will share with us tonight. So on the basis of that segue, let me now introduce you to Dr. Margaret Hagan. Before Margaret took on her current role as Director of the Legal Design Lab, she was a Fellow at the D School from 2013 and 14, where she launched the program for legal tech and design, experimenting in how design can make legal services more useful, more usable, and more engaging. She teaches a series of project-based classes with interdisciplinary student groups, tackling legal change and challenges through user-focused research and design, and looking at how to develop new legal products and services. She also leads workshops to train legal professionals in the design process to produce client-focused innovation. Margaret graduated from Stanford Law School in June 2013. She served as a student fellow at the Centre for Internet and Society and president of the Stanford Law and Technology Association. While a student, Margaret built the game app Law Dojo to make studying for law school classes more interactive and engaging. Now, I had hoped to look up Law Dojo this afternoon and for various reasons wasn't able to, but I'm hoping that by the end of the evening at least I'll have a keen appreciation of what that game entailed. Possibly law school study at Melbourne can also be made more interesting, although not more rigorous. She also started the blog Open Law Lab to document legal innovation and design work. Margaret holds a BA from the University of Chicago, an MA from the Central European University in Budapest, and a PhD from Queen's University Belfast in international politics. She is originally from Pittsburgh. We are fortunate indeed to have Dr. Margaret Hagan here with us this evening, and it's an extraordinary pleasure to welcome her. Welcome, Margaret.
Hi, everyone. So I've got a lot to talk about. I've got a lot of things to show you. But with that said, I hope that you'll interrupt me if anything's not clear, you have any questions. I'll save plenty of time at the end to have more of a discussion. I might even interrupt myself and have an intermission where we can have some talk back, just so I'm not speaking for too long without giving you a chance to speak back. But with that caveat, let's go ahead. Does the clicker work? Let's see if the clicker works. Let me turn it on. First step. So the theme of tonight is how we can make the legal system work better for people. And this is from many different people's perspectives. So whether it's from law students who are just entering into this profession, whether it's people without lawyers who are going through a court case and trying to figure out how to navigate a process, or whether it's lawyers and court professionals themselves who know that the system is dysfunctional, who know that their day-to-day work life is not as satisfying as it could be. I think across the legal community, there's a growing realization that these dysfunctions need to be fixed, that we need to be devoting more of our work and our attention and our budgets to figuring out how to make the legal system work better at the corporate level, at the access to justice level, at the education level. But the problem with the legal system is there's so many problems, and there's not a clear way to fix them. There's lots of ways we could be spending our energy and setting the agenda. So today I'm going to talk about the reflections that our team at the Legal Design Lab at Stanford, which has been working at these various levels, at the corporate level, at the access to justice level, at the education level, where we see opportunities, where we see methodologies and research opportunities, as well as where we find actual practical solutions that we can be funding and scaling up. So I'll be, here's a little bit of the map of today's talk. There's that line down the center is an intermission where you can interrupt me and prevent me from talking too much at you. But in the first half of the talk, I'm going to give a little bit of a primer on what I mean when I say the word design, what this approach can mean for lawyers in particular, what it can achieve, what it can do, and tell you some stories of how we've been using it and other people have been using it to make innovation in the legal space. Then after the intermission, where you get a chance to talk back, then I'll go into more of the lessons learned, reflecting back on the past 5 years of work and projects and research to lay out some of the best practices that we've seen, as well as some of the ways that we, in the innovation community, in the design and technology community in law, need to be doubling down our efforts. And I'll leave with some kind of very practical things. I'm a very practical person, so if you want to work this way, I'll lay out some pieces of advice. But that said, the discussion time will be yours. If you want to ask me other questions or want to talk about other things, I'm happy to be interrupted, as I said. So to begin, let me start with how innovation's going wrong, as I've seen it talking to a lot of different law firms, public agencies, courts, and law schools. There's 3 big fail points that I see. I'll suggest some strategies to address them later, but let's just start with the fail points of how when people are trying in law firms, legal departments, courts, law schools to innovate, how things are going wrong. The first big one is that lawyers like to build things without testing them first. So with a lot of confidence that they can solve people's problems, they spend a lot of money on projects that ultimately don't have impact, that their intended audience don't engage with in the way that they want to. And I think a lot of lawyer technologists will admit that they build applications to help people expunge their records, clean their criminal records, or to sign people up for benefits, or other kind of well-meaning initiatives that then no one ever downloads, no one ever visits, and there's not the impact that they're aiming for. The second big failure we're seeing is that people, especially in bigger, more traditional organizations, set up innovation initiatives that never go anywhere, that it ends up in a theater performance of lots of sticky notes and talk about brainstorming, but no actual building of things, launching of things, testing of things. So kind of getting stuck in the talking and the planning and not the doing and the testing. And the third big fail is classic. Someone, usually an older person with a fair amount of power or seniority in an organization, has a great idea of how to solve a person's problem or an organization's problem, and it gets funded, you put a team on it, you start building, but it's not the right solution. And this happens all the time, whether it's judges or senior partners or law school professors, people who try to do innovation without actually going through a process, but just jumping straight to a silver bullet. So this is really where a design process and a design approach can help us spend our money better, spend our time better, and use this energy for innovation to actually get to impact. So when I say design, it's a nice complementary pair of glasses to wear when you're not wearing the glasses you've been trained as a lawyer to wear, the super analytic, the critical thinking, the very rational glasses that we are trained as lawyers and legal professionals to wear. Design is a different pair of glasses to wear. It's a different thing. It's a different way to focus on problems and to go about solving them. When we look at a systems problem, a services problem, or an organizational problem as a designer, we focus on different things than we do when we're thinking like a lawyer. We think about people's experiences, what the empirical realities are on the ground. So kind of valuing what people say, what they feel, what their frustrations are, looking not just at law on the books or law as written in rules and procedures, but really valuing people's lived experiences as something worthy of paying attention to. The second big frame is really focusing on solving people's problems. That's the measure of impact. That's the measure of evaluation. Are you making people's lives better? And working with anyone else who is coming from a problem-solving discipline. So whether it's engineers, designers, social scientists, educators, trying to find other people who are working on a similar life problem as a lawyer is, and making those teams that can effectively come together to actually solve problems. And the third is seeing the system as a series of touch points in a flow, meaning not trying to solve a systems problem by focusing only on one part of it, one interaction, one rule, one thing, but seeing how interconnected it is and how people journey through a system and how we can support them through it. What that looks like a little more practically is when we try to solve problems using a design approach, we go out and we listen and we talk to the community as kind of a first precursor to everything, but then throughout our problem-solving process. So trying to be directed by the people who we're trying to serve, rather than being separated out and building something in a vacuum, putting it out into the world and hoping they'll use it. We tried to build things alongside the people who were hoping to use it, to let their expertise guide it, and to make sure that their values, their needs, their preferences, and their technological capabilities are all accounted for in the design. And finally, and probably most importantly in the design process, it's the spirit of experimentation. So not writing bullet point lists, not writing memos, not speculating about how we might solve a problem, but building something, putting out into the world, seeing how people truly behave, and then going back and iterating and building again. The design process, if we want to be fictitiously clean about it, looks like this as a little recipe card. It's never this clean in reality, but this is how we start teaching our students about how to solve a problem like a designer. You start off in a discovery mode, talking to as many people, gathering lots of data, doing a background analysis, much much like you would if you were starting any other research project. Who has tried to solve this problem before? Who are the main stakeholders? But only after doing all that gathering of information do we start to decide what's the real problem we're going to solve, how to frame the challenge that we're going to spend our time on. And then from there, we go almost instantly into a building and testing phase. So trying not to plan too much, but as soon as we know what challenge and whose challenge we're trying to solve, brainstorming possible ideas, building first versions of them, testing them to see how people behave, and cycling through several versions of that until we have a promising thing that we would actually commit resources to. That means a lot more messiness than most lawyers or researchers are used to. Design is a lot about divergence and experimentation at the start. So not going in with a perfect plan, with a method of exactly when you'll start, what you'll achieve, what the outcomes will be, and what to expect. There's a lot of messy playing around at that beginning to try to get the problem right and the solutions right. And then from there, focusing in and spending money and resources in a meaningful way once you've vetted something really well. Going into that process, these are the mindsets that we teach our students and legal designers to wear. I won't go through all of them. They're on my website. You can find them and go through them piece by piece. But a few that are particularly uncomfortable for lawyers, thus worthy of talking about. Pausing feasibility and suspending our constant need to figure out how things will go wrong. Of course, that's a very valuable skill. That's why lawyers are hired and so useful is figuring out the risks and all of the ways that things can fall apart. But that skepticism and that cynicism, that analytical thinking is also a hamper on creativity. And so that's why, especially with our law students and lawyers, we have modes where we go into a world where everything is possible. There's no budgets, no rules, no constraints, and try to think about what if. So what if everything was going our way? What if it was 20 years in the future? How do we really set our ambitions higher and think about a different world? So this design approach that I just talked about, this process, these mindsets, it's been spreading across especially professional services fields over the past 20 years. So it started out mainly in consumer products, like Nordstrom, a department store in the States based in Seattle, who opened a design lab and built a big design team. Or technology companies like Samsung that make physical products and software, as well as IBM, kind of players from Silicon Valley or the technology industry that you would expect to be investing in different modes of innovation. Intuit that does TurboTax and other kind of accounting softwares. All of these companies are putting design as one of the main management principles. So hiring a lot of designers, giving them a lot more leadership decision-making, and trying to imbue a culture of design across their company. But even outside of software companies and technologies, now design is coming into the world of professional services. So for example, Fidelity Investments, which is a financial company in the States, has a huge design lab to come up with new products and services or to rethink the traditional business models. Or insurance companies are working with design labs to create something like a society for grown-ups. How do we help young Americans adult better? How do we, as an insurance company, a very traditional organization, capitalize on a design-driven approach? Or hospitals, the Mayo Clinic in Minnesota has designers going around following doctors when they give patients their cancer diagnoses, or when they're having team meetings and deciding on strategies, thinking about how design could be brought into doctors' and patients' practices. And now it's coming to the federal government, too, in the United States, at least under the former administration. The Office of Personnel and Management, a federal agency that oversees all the other federal agencies, has a design unit that's kind of a roving body to help the Department of Defense, the State Department, any other agency that wants to think about an innovation unit, to be trained in design, to use these methods to make better public policy. And we also see it at law firms. So Baker and McKenzie, as of a year and a half ago, opened up a standing design initiative, CoLab, and a big design competition for their lawyers. We see another law firm in Minnesota, Faegre, who have built their own design lab and are teaching all kinds of IP lawyers all about human-centered design as a way to better serve your clients and convince juries and judges on your case. In Finland and Italy are two of the big centers on legal design, where there's businesses, law firms, and universities working on this in a pretty concentrated way. So a law firm in Finland, in Helsinki, Dotir, spun off their own legal design agency where all they focus on is design work, service design work, mixed with legal advice. A graduate and a friend of mine from Harvard Law School opened her own company called the Graphic Advocacy Project, where all she does is better design for legal communications and know your rights materials. She has incredible business. There's so many people who are trying to hire her for that. And then we see the rise of it in law schools, where we see a list of about 15 law schools in the States that have legal design labs or the equivalent. And even just today on LinkedIn, someone sent me this. There's a whole other legal design thinking consultancy opening that's kind of really hitting law in the past 2 years and spreading quite rapidly. Now it's at the law schools, consultancies, law firms, and legal departments. And it's kind of funny. When I first started working in these two spaces, which was serendipitous for me, I just started law school and I was proofreading my then boyfriend, now husband's PhD in design. And I thought I was just helping him correct the English on it. I thought design was just about, what Steve Jobs did, whatever that was, or making PowerPoints, I had no idea. I come from a very social sciencey background, and because he was my boyfriend, I proofread his thesis. But as I was reading it, I was in the middle of 1L, which I hated, but as I was reading it, I was like, oh my gosh, this is what lawyers need. A focus on interactions, a focus on people, a focus on how to make things better in a very practical way. But for the first 2 years or 3 years, when I was at law school and trying to figure out why aren't more lawyers looking at design, the pushback I got was that it's not for us. That's for another type of person, whereas people who self-select to be lawyers are not creative people. They came to law school for a reason. But when I've been leading a lot of workshops and doing a lot of classes, I realize it may seem radical, but it actually is quite intuitive. Most of the process and methods that I've been talking about, the mindsets, it's very similar to how lawyers often solve problems or focus on their clients. But it's just a way to structure it more and to keep us on task in a better way. So kind of what I hear when I run workshops, kind of the initial resistance is like, this is not the way we usually work. I'm a little bit uncomfortable. And I think a lot of that has to do with the way of thinking and why design actually has a lot of potential, which is this power of abductive thinking, not to get too jargony. But this way of kind of letting serendipity and randomness and all the wonderful things that can happen when you work with people outside of your discipline, or you talk in ways and work in ways that you don't normally, and bringing all of that power in to be inspired and to find new ways to solve problems. Whereas often as lawyers and other professionals working in big traditional organizations, we get stuck in more traditional inductive or deductive ways of reasoning and thinking, and we don't kind of let in these sparks that could drive us towards better solutions. And I feel like a lot of lawyers, especially those who see the dysfunction in the system and want to make their own professions and their clients' lives better, they're willing to try it out, which I'm very excited about. So let me talk about what it can actually do, giving all this background on the approach and the promise of it. When we think about where design can actually make a difference in law, I like to think of it in tiers, in this triangle, where we can think at the very top, like my friend Hallie, who runs the Graphic Advocacy Project that I showed you. She focuses on communication design. So taking posters or fact sheets or bench cards or other things, kind of static, two-dimensional communications, and making them better so that people would actually look at them, be able to comprehend them, read them. That's communication design, visual design, and clearly we have a lot of communications in the legal system that could be better designed. But as we go down the pyramid, we get to more complex types of problem solving and a lot of potential. So we can think about product design, much like Gary's students in his law apps class are building technological products that can simplify how a person goes through a process, help them achieve a task. So tons of ways that technology and non-technology could make better products in law. But then we get down to more complex things like whole new services, new organizations, new systems. Can we use design to change how our actual rules of a civil court are set up, how a court is structured, who's allowed to practice, how services are delivered. These are really interesting questions. We've been starting to get more complex in our own design processes, and I'm very happy to talk about them more. So let me talk about specific problems now, about where design can be brought in. So I have a lot of people who come into my inbox or show up at my doorstep or at the design school, and they all come with their problems. Here are the main categories of those problems from lawyers and courts. First of all, better legal communications, that kind of top of the pyramid type of challenge. We just want to make our disclosures or our privacy policies or our rules better so people actually know what the legal system is about, know what to expect. And I think we have pretty good methodology for dealing with that. As we go down, applying new technologies, a lot more. I think in the past year and a half, the most popular queries have been around culture change in law firms. So whether it's about retaining lawyers, preventing substance abuse among lawyers, making organizations less dysfunctional and less painful to work at, and also thinking about how do we make firms, legal departments, and courts more adaptable, more flexible, and more innovative at the core? How do we get people to be thinking strategically, thinking about new business models, and getting ready for the big market changes that are already upon us in the United States? Let me show you some specific examples. I'm just showing you the question and some end product. I'm not showing you how we got there, but I'll get to a how we got there story soon enough. So a big legal department came to us with the challenge of huge numbers of contracts going through their technology company, very little oversight of what was inside those contracts, and lawyers and salespeople not talking to each other about what was inside those contracts, just pure dysfunction at a massive scale. So the students worked with them for about 18 weeks to come up with an automated contract builder, where the lawyers would set the terms, the service or the salespeople would have to live with inside those terms. Everything would be automatically tracked and data captured at every point so that there would be clear oversight and stats gathered. We prototyped it, handed it off to the technology company to implement. We don't follow through. Our lab is not a consultancy, so oftentimes for for-profit companies, we hand the prototypes off. They can adapt and use them as they wish. Another one, more of our access to justice problems, is we are focusing on the homeless population in San Francisco, which is substantial, and how they often get off track when they've come into a social services agency and been told that they need to go fight an eviction notice or go to deal with another problem in the civil court system. So the question was, how do we keep them tuned in and on track once they've started their legal journey? So the students did all this research with different homeless populations around the Bay Area, and then designed both a texting app and a smartphone application to create an action plan and all of the kind of coordinated services, maps, follow-ups, all those things to help a person stay on the path of getting social services through the courts. Another one, this time it was from a law firm where they were thinking about first-year associates in the States who, unlike in Australia, have almost no practical training going into a very highly paid job. And oftentimes get put on a trial team without any preparation and never having been told how to perform well on a trial team. So the students interviewed and watched and tagged along to how trial teams actually operate, and designed a video sharing platform where experienced lawyers can share their war stories and their fails and all of the things you kind of need to know on the ground to actually know how to operate in a trial team. And so the law firm is now taking the prototype and having all their lawyers record short 2-minute videos to be shared internally. A more challenging one, we get this one a lot. How do we use blockchain in our law firm or our legal department? Where there's a big promising technology and people who have read about it and they think we want that technology, but we don't know how to apply it and what it would be good for. So we want to figure that out too, but we as human-centered designers want to make sure it's actually solving someone's problems. So we've been running kind of these emerging technology workshops where people come, like a big technology company, in this case Cisco, with a possible use case. We think blockchain might be useful for tracking all of our inventory of prototypes. That seems like it's right, but how do we actually make that system? So after a team of lawyers had spent about a year of making bullet point lists about how blockchain might be useful, we went onto the floor with our team of students, and then we started mapping out exactly how blockchain could be applied, whether they should just be building a big old database or not, but trying to actually make this big, abstract, scary thing called the blockchain apply in a very concrete way to a real-world problem. And finally, this is a simple document design, but I think ingenious. One of my students got really good at making hospital bills. So if you've ever been in the US, you know that healthcare is terrifyingly expensive, kind of poverty-inducing expensive. So we had the challenge of how do we help people who are leaving the hospital facing huge, massive debt actually know their rights? Because hospitals usually have a program called charity care, which would give people most of their money forgiven for a big hospital bill, but they only tell people about it in like 8-point font somewhere in a break room in the hospital that no one would ever see. So the students came up with a wonderful new hospital bill redesign that would have giant on the back of the bill an explanation of exactly who qualifies for charity care and how to take advantage of it. So now we're also trying to do a rule change in California that hospitals would be mandated to have a disclosure like this on the back of the bill. One of my students is terrifyingly good at making hospital bills now. She actually sent me one in the mail to see how I would react. It was very scary, but yeah. So with all those little short stories, I wanted to just give you a glimpse about how many different types of use cases and challenges there are. Let me talk a little bit about those fail points I discussed at the beginning and why a design approach can help us be better at that. So for that one of making things that we think people should use, but then in practice they don't actually use, the real value of design work is making us think outside of our own legal professional mindsets, that we get so ensconced in how we work and how we think of the world that we forget other people don't see the world in our mental model. And to do that, we have to go out and we have to talk to people directly. We have to defer to their expertise rather than that kind of perpetual lawyer problem, which is also a perpetual engineer problem of thinking we always know best. So for example, this scene comes from the D School, where then Attorney General Kamala Harris in California, now Senator, had a task force that was trying to get young people over the age of 18 in California to clean their criminal records. It's kind of a no-brainer. Actually, it should be a policy that just everyone's eligible criminal record is cleared, but it's not. You have to proactively go and sign up and go through a lot of paperwork to clear your criminal record and thus be more eligible for housing and jobs and other social benefits. And the question the DOJ had was why people weren't using their government website that they had built and thought, young people use websites, let's put a website up, people will come to it, and then they'll clean their criminal records, and there was just no traffic. So we called together a workshop where we had 20 people from the East Bay, from Fremont and Oakland, come in. They all had criminal records and were young people, so our demographic. And we asked them to use the government's website. And you can see mapped out, they have a like, dislike board and an ideas board. What don't they like? What do they like? What could be better? So we get that feedback, almost like a focus group. That's great. But then what we have scattered around the room are designers and technologists to work with the young people to then create the better way to get young people to clean their criminal records. We also had court people and DOJ people there too, so that they could give us advice or maybe even open their minds to changing the rules to solve the problems themselves. Does anyone want to guess what 20 young people from the East Bay in California came up with, what they proposed to the DOJ to make a better record clearing initiative? Any ideas, hunches? Text? Why do you say so? Who said that? Yeah.
Well, maybe they're already using text for other things.
Yeah, we thought text, but they didn't want text because they wanted more context, color, and information than what SMS at least would give. But they wanted conversational. Say again? What about graffiti?
Street art or something like
No, nothing that complicated. Yeah. An app? No, they didn't want to have to download anything from the court onto their phone or government on their phone. So don't build an app.
sit with them and go through a piece of paper and...
Fictionally. So what they wanted was a celebrity to chat with them on a website. A celebrity that they knew and trusted. For them, it was Rihanna and Chris Tucker. So you could choose, and then their little avatar would then go back and forth with you about what you needed, what to do, what other people have screwed up on, and then fill everything out. And what color scheme? If you even had to guess what colors, let's just say what colors. Of course, the original website was traditional, dark blue, conservative, like a law firm or a government site should be. What do you think the young people wanted? orange. They wanted bright pink and lime green. The DOJ's head exploded. Can this be a DOJ thing if it's bright pink and light green? None of that. This was such a relatively easy and cheap investment. Rather than having conference calls and listening sessions and kind of long-range planning to get input like this, we had food, we had donuts, we had a bus that brought them over. We gave them design training as a way to compensate them for their time. But in 2 hours, we had so much feedback and guidance to hand over to the DOJ. And obviously, it's a small sample, but it's a way to at least start making something that they could test at a wider scale without just assuming that they, as the DOJ, knew what young people wanted. I won't give you the full backstory on this one, but it was in Pensacola, Florida. I'll tell you a little bit more about it later. But it was a woman, the woman on the left, Erica, she runs a foundation in Florida that tries to get people who are leaving prison into a social network that prevents them from going back to prison. So we ran a big design workshop with guys who are technically still in prison to design what services they would need, where they would like to access them, and how they'd like to access them to prevent them from going back to prison. So the two gentlemen on the right are technically still in prison, but on release that day. And they're sketching out, how would you help me to not go back to prison? For the second innovation fail, this kind of theater of too much talking and too much planning, where design can help is forcing action. And this is where the process, that kind of recipe card diagram I set out for you, is good as a forcing function to make people act. Because oftentimes, and I have sat on so many of these, I should have been more forceful and just said, we must stop this right now. But there are so many innovation committees that are run around a boardroom table with a bunch of very smart people drinking coffee and chilled water and talking about what could be better, and then nothing happens. So we have to think about forcing ourselves to go out in the field to observe and to talk to people, to work with them in a very physical and visual way, but getting out of this very comfortable boardroom setting and thinking that we can innovate that way. So yeah, this is another high-powered legal foundation professional who is drawing an entire scheme of how a new application will be developed. I was just very happy, so I put this picture up because it was a non-talking picture. The third big fail, the one of a senior person having a great idea and everyone going along with it before it's been tested, that's where that prototyping and testing loop is so beneficial. So if we can come up with prototypes where we can test how people actually behave in response to an idea really early in a project's timeline, before we invest all those resources, we can bail from bad ideas more quickly. This is why we use prototypes. So whether it's in Post-it note forms, drawing out, storyboarding, sketching, we try to work really cheaply, easily, and quickly to make ideas manifest, to make them testable in that kind of early exploratory way so that we don't invest resources in a bad way. So let me walk you through an actual story of how this plays out in practice, a full-blown journey through the design process. So this is one that's actually been going on for a few years. It's a long story, but we've been working with the California State Self-Help Centers. I'm not sure if your civil courts have free legal services for people, if you call them self-help centers or not. But basically anyone can walk in regardless of income eligibility, and they should be helped with navigating civil process, just not legal advice. And this is what it looks like on the ground. This is at about 8 a.m. on a Thursday morning in San Mateo County in Redwood City, so like 20 minutes away from Stanford. These are people waiting to maybe see either a law student or a lawyer for 20 minutes to help them fill out forms. And the line at 6 a.m. was all the way down the block of people even waiting to get a ticket to stand in this line. So people are queuing all morning long for 15 or 20 minutes of free help. If you actually walk around the building, it's a depressing government building, that's fine. So we've run a series of classes where we've been on the ground doing different versions of this process, mainly in California, though with some parallel classes in Boston and in Alameda County near Oakland, California. So these are some of the classes we've run, prototyping access to justice. How we started off is in this discovery empathy mode. So we don't define what the problem is. We know there is a problem. The courts have come to us. They say that people are not getting served, they're not happy with the service, and they're not navigating the process correctly. So we go and hang out and we try to figure out how we're going to frame this challenge in a way that we can actually come up with meaningful solutions. So we sit there and we just watch for 2 hours and draw what's happening. We observe how lines flow, where people get really frustrated, where they're mad, where they're angry. We sit in the service centers and the self-help centers, and we see how the interactions go. We do exit surveys of how people's interactions have been. We make the students all file for divorce or petition for an eviction, playing the landlord, or respond to an eviction notice, playing the tenant, but have them actually walk through every step and fill out all the paperwork themselves. We do a lot of interviews with people about how, have you just gone in front of the judge, how that went, if you felt respected, if you felt that you got a fair outcome. We interview advocates, we interview court administrators. We try to talk to everybody within the system, see all of the stakeholders' perspectives. And then we start to think about what could be a future. So we envision how we might change the space. We go back and we start to synthesize. So this is at a Phil's Coffee outside of that San Mateo County Court. We start to just spread out. What have we seen? What have we heard? We're not going to judge exactly where our direction's going to be. We just kind of spread it all out. And we start to debrief, find where there's opportunities, make notes, map out the process, exactly all the steps that we've seen, what that process looks like in terms of the spaces and the forms and all of these other touch points. Draw out from the litigant's perspective, from the user's perspective, all the different things they've gone through, where there's low points, where there's high points. And then we start to see where are there opportunities. So this is one of our annotated maps. If a person's journeying through the court system, where are there specific opportunities where we could be designing new products, new services, new technologies? And then we start to focus in. After we've laid all that information out, we say, are there common archetypes of the people that we've seen? Are there certain types of users where we've seen a number of them, there's a pattern, and we could maybe make them a focus of what we're designing? We propose new concepts, so we do wide-ranging brainstorms where we pretend that the civil rules of procedure don't apply, there's no court budget restrictions, there's amazing technologies that have not been built yet. What could we do? We sketch out these ideas in kind of one pages, and we make catalogs of them. And then we go around to stakeholders and we show them a catalog of ideas and have them rate or spend fake money on which ideas they think are actually valuable. We go into the field. This is Alex, one of our designers. He's making new signs that we can print out and put on the walls right there. So we try to put our prototypes right in the field. You can also see tape on the floor where my students have made a red line from downstairs to the self-help center. The courts don't stop us. We just do stuff and nobody is even watching. That's cool. And we start to make first versions. So my students made, if you're going through child custody, here's a little triangle man who will guide you through exactly how to get through your custody case. We actually had a designer from Apple. I don't know if you have Apple stores here with the Genius Bar for the waiting areas. So we had the woman who's in charge of the Genius Bar design for Apple come and advise our class on how to make the waiting experience in the court better. And we've tried to draw on all this expertise that we have in Silicon Valley, all these really great designers and technologists. We invite them in to be pro bono coaches to solve social problems with us. So it's a wonderful thing to do. I know Melbourne's got a wonderful design community too, how to pull non-legal people in to help us solve our problems. And then we do a lot of testing in this kind of way. So you'll see very cheap materials here. This was from one of our classes where a big proposal had been to have virtual court, where you could Skype a judge. So instead of actually developing that application, we just had some poster board and Post-its on it, and we went around and we said, you just got a traffic ticket, like walking across campus. Do you want to Skype a judge? And we saw if people press the button Skype a judge, or if they press the button fill out a form. If they press the button Skype a judge, then Melissa, the student, would hold up the next piece of paper, which was a poster board with a hole cut out of it, and she would say, what's your plea? And then see how people reacted. And see, like, what's the level of formality if we have a virtual judge? If the judge is wearing a t-shirt, like, how does that change stuff? But we try to get that behavioral testing, not asking people in the abstract, what do you think about having a virtual court? But how do we make a skit or an enactment that makes them really feel it, and we can see what their gut reactions are. Or this is a court kiosk, where again, instead of building a court kiosk, we just put a box over one of the students' heads, and he pretended he was a robot in the lobby of the court to see if people would talk to him, or what they would want to do with a robot in the court. We do a lot of guerrilla space redesign, putting up signs or doing other things. We also do a lot with Craigslist and other places where people are looking for kind of short gigs, where we invite them in and we have them test our ideas or help us totally revise. So trying to do that at least once a month, where whatever prototypes we're working on, we invite the public in, especially people who have already been through that court process, and have them tell us everything that's wrong with the ideas that we're working on. We do a lot of presentations to bring the partner along. We have really good relationships with the courts in California. They're actually very interested in how to innovate. They just feel they don't have capacity themselves. So we try to educate them at the same time as we're educating the students about how to use this process. We take the prototypes, more prototypes. I won't go through all of these, but lots of texting, digital guides, visual guides. And then we take those exploratory designs, kind of that are somewhat high fidelity. Like this is a guide to, if you get a traffic ticket in the US and you have to go in front of the judge, this will tell you what your 4 possible pleas are and what the consequences of making those pleas are. So we get to these somewhat vetted designs after putting them through a battery of user tests and partner tests. And then we think about how do we make this into more of a research project where we can evaluate in a meaningful way whether this actually has the impact that we want it to. So through a randomized control trial or an observational study. So for example, right now in Orange County, California, one of the students' projects about text messages about where you are in the very lengthy process of getting divorced. Usually it's over a year, if not a year and a half in the States. This text messaging system will tell you exactly what your next deadline is, if you've done anything wrong, any hearings that are coming up. And we're seeing, do people actually sign up for it? Does it make them show up to all of their hearings, file their papers more correctly, and get to a better outcome? So we have a massive recruit going on right now. We did a first 2-month version of it, and now we're doing a big 6-month version of it to see what the actual impacts are. I'm going to take a pause, a deep breath. Does anyone have any questions or thoughts for me before I talk a little bit more about lessons learned and future agenda? Now's your chance, please. I try to talk to people low on the ground who aren't thinking about big public expectations or blowback. Because obviously California courts, every court is very worried about how they're covered in press, how the legislature appraises them, and a little bit about public blowback. But I think I try to partner with people who are living the front lines of customer, client, user, court user experience and want to find out how to run their own center better. So we try to also frame things very deliberately that we as the unit, the law school team or the design lab team, that we are not the court, that none of these are real, that all of these are fictional products that are hypotheticals. But we know that people still might then interpret it as this is coming. But I think the court, they like having us as an outside group that is framed differently, that we can also pay people. That's another problem with user testing in the courts. They don't have a budget and they're very hesitant to pay litigants. I'm not sure if the same rules are here in Australia. But that's why it's wonderful to have a law school court partnership, is that we can take a lot of the, not liability, but the steps that they can't take as a public agency that we can take as an outside group. I'm not sure I can totally answer your question, but we can talk offline about how to build that confidence for user testing. It's a big question. I think both. So I think number one is the divide between legal information and legal advice. I'm not sure if that's also in the ethical rules here, but it is clearly the main thing that people want is legal advice. They want customized information to their situation that they can rely on. And what we see now is that they grapple with, the jargon and the bad formatting and the inaccessibility on the technology of the information that is legal information. So there's ways to make the legal information more accessible and plain language, more visual, all of that's good. But really what people want are strategies that they can apply and that they are not left juggling all of these different abstract pieces of legal information. So that's where we're talking with the courts about how far they can stretch into something that's more customized. I don't know how the regulation works here, but public agencies in the US have the biggest latitude to move there because the bar is not going to sue them. How would that look for the bar to be suing the courts? But I think there's a clear need to rethink that ethical rule. Obviously, there's good reason for not giving automated, customized advice, but that is what people keep demanding. So that's one of the big tensions of this human-centered design, is when the rules of professional conduct and the ethical rules are directly in opposition to what we keep hearing people want. One more? Yeah. So this is getting into my part 2. Let me just go right to it. So I think the level of ambition, we started out pretty humbly in our design lab, where we were taking the challenges as framed to us and the rules of ethical responsibility and the civil rules as a given, and trying also not to be too threatening to our partners, saying we're going to come in and we're going to blow the system up and we're going to start from ground zero. It's easier to say we're going to work on communicating better or making your legal information more engaging. So it's easier to build partnerships that way. But I think as we reflect, as we map out these processes, we see the dysfunctions, we see where people tail off and drop off from legal processes. There's clear rules changes and policy changes that need to be made. So that's where we are not exactly pivoting, but we're definitely expanding to think about how we have those conversations with chief justices, with bar leaders, with other policymakers in this space, and use the design research and the prototypes as one piece of evidence that we can show if we could change this rule, or at least in a sandbox, try out changing this rule. Can we see if we get to a root cause, a new solution? So this is a new era. I think we have, with the access to justice crisis as bad as it is in the US, we have a lot of leadership interest in how do we prototype and test new rules, new court structures, new processes. We're trying to figure out that methodology right now. It's a big open question. Most of these government policy labs, it's really hard to prototype new systems in the same way that I've been talking about as new products and services. So we're entering into that era right now. Let me just run through a few points before I open it up totally. Here are the big things that I, after working in this way for 5-6 years, feel that we should be focused on. So one is ambitious design work, because at least in the US, lawyers and courts, like the market changes and the access to justice crisis, it's here, it's real, our hair is on fire, and we need to start not just speculating and thinking about changes, thinking about new ways of doing things, but actually testing them out, trying them, and laying the innovation structures, changing how we operate as our organization, that we can start responding to these fires. That means moving, as I was just saying, from kind of first order, top of the pyramid designs, designing new communications, new technology products, new apps, to really focused on changing the systems, the rules, and the policies in a more human-centered and exploratory way. And that means investing in this in our own organizations, so not assuming that we can hire either a law school lab like mine or a consultancy coming in from the outside, but we need to be opening up these spaces inside of our traditional legal organizations, whether it's a court, a law firm, a legal department, a legal aid group. How do we start experimenting and building this capacity to innovate inside of our own groups? So I think there's ways to take on these roles without going back to school or going through a big innovation course. A lot of it's using these methods that I've been talking about to bring stakeholders together and facilitate these discussions, to start experimenting, to start doing more of this research and going out and testing new products and talking to court users, other users. And we also need to think about partnering in a better way. A lot of these initiatives, innovation initiatives, have been very fractured by geography or by university or by these other barriers. So this year at Stanford, we're running our classes in parallel. So we're trying to tackle the same challenge with a similar curriculum as universities in Colombia, Guatemala, and Mexico, to see that if we're designing in a certain way for the courts, and each of our classes in these different countries are, can we come up with solutions that can spread more easily, that we're building for scale from the very beginning? So design locally, but then think globally. More of this. And I saw 2 law schools in the US just partnered. Brigham Young and University of Arizona are both tackling eviction at the same time. So designing in Arizona and Utah, seeing what they can come up with together. But how can we work together? I think this is a big priority. We need to double down on how much we talk to people in our community, so the actual users of the legal system. I'll breeze through this really quickly because I don't have time. But most of the things that we build are not actually designed by the people who are going to be using them, and that is a big problem. So this project that I mentioned with prisoners in Escambia County, we took these methodologies that came out of Scandinavia, all this good participatory design, co-design. Northern Europeans are really good at being participatory and democratic. Panhandle of Florida, not so much, but we brought it down to Pensacola, Florida, right on the border with Alabama, a big military pro-Trump town. So we did it in a halfway house for people who have gotten out of prison. We had them in charge of saying how foundations should be spending their money. We brought in, again, soon-to-be former prisoners to tell us about their lives, to vote on the ideas, to design the ideas, to prototype and test new apps, to make presentations to foundations and local leaders about how they should be spending their resources, then to vote on the ideas and come up with a list of top 3 ideas that should get the money. These were the 3 ideas that came out. I won't go into detail. I'll talk to you later if you're interested. But they were all actually run, put into the field. We're gathering data on their usage. And what we learned is that this idea of user testing and talking to your community, it sounds expensive, it sounds hard, with lots of ethical pitfalls, dealing with prisoners, dealing with populations that are really diverse, but it is actually not that hard. It's about finding local partners on the ground who already have the trust of those communities and using them as a way to invite people in, make them feel comfortable, and then give them the deference to their own expertise. I'll breeze through these just for time's sake. This is what we learned in terms of how we actually serve people who are going through these things. I just wanted to make this last point with my limited time, which is also at the same time as being really community focused, working a lot more on emerging technologies, which may seem different. How do we work with AI and at the same time work with prisoners coming out of prison in Pensacola, Florida? But there's so much demand for artificial intelligence as a way to address the access to justice crisis. Almost every different type of demographic that we are talking to wants customized, conversational, and immediate support from their technology. And that means laying this groundwork for how we're getting the data from courts, legal aid groups, bar associations that will help us build the better AI. So that's another one of our big themes, our expanding themes in our design lab, is to not just focus on kind of web design, digital design, app design, or SMS design, and really focus on gathering data and laying the groundwork for ethical and human-centered artificial intelligence. So again, I'll breeze through this pretty quickly, but we're working with Google and Microsoft to change how search results are shown, because we keep hearing how people start at Google when they're trying to figure out their legal strategies. And I don't know how it is in Australia, but search results in the US are pretty poor, not jurisdiction correct, oftentimes from private parties, oftentimes even purposefully taking legal aid groups and trusted authorities' branding and directing them to for-profit and not so respectable groups. So we're focused on how we can make the internet a better place to find good, reliable legal help. That means we're combining AI research with our design research. I'm going to, again, breeze through this really quickly because of time, but I'm happy to geek out about this after if you'd like. But basically, we have a huge data set of people talking about their legal problems on Reddit. They give the backstory, and a little bit of advice happens there. And we have the same thing from the American Bar Association's online virtual legal clinic. They've shared their data with us as well. So we have a team of lawyers. You're welcome to come join, learnedhands.law.stanford.edu, who are labeling all these posts and saying what legal issue is present. The interface looks nicer than this. It's a fun game. Go play it. But with all of these lawyers and law students labeling the issues, that helps us create a labeled data set, which is the goal to help us partner better with people in deep learning, machine learning, natural language processing. What they want is a structured labeled data set to start creating new machine learning models that we could use. So the goal is that we can put in a query, whether it's from Google or a Reddit post, and the machine learning model can predict what issue is present or not present. So right now it's calculating if someone types in, I don't know if I want a dissolution or a separation, what's the percentage that that's a family law issue? 99.9 0.95%. And we're getting to more specific issues. So we have the broad categories like family or debt and money or criminal, but we're also labeling at a much more child level, like a specific type of divorce or a specific type of cleaning your record, but that we could get people to the right resource more directly. So we're trying to create a Rosetta Stone. So if people have a Reddit post or a Google search about a specific normal person phrase, we can pair them with the court resource or the public online legal resource that matches exactly what they're asking for. I won't go into all the gory details of all that, but we're trying to do it in a human-centered way. We have Google at the table, Microsoft at the table, legal aid groups at the table, court folks at the table, trying to get them all together and agree commonly about what's good, and the users. Yeah. And then we're testing this out. We're testing Wizard of Oz prototypes about what a better Google search results page could look like, or a Twitter bot that would DM you if you tweet about a traffic ticket or an eviction notice, how we could help you. P.S. Nobody likes a Twitter bot texting them about legal help, no. Or how we could put this at different social service agencies, so as they're doing their intake on another issue or another matter, it could ping about what legal help might be available. So we're testing those out. We're thinking a lot about ethics and professional rules and opening data. And we're partnering with all the organizations that could actually help us implement these, Google and Microsoft. Let me just finish. I know I'm over time already, but a few things about what you could be doing now. So if you're thinking, how do I actually make any of this matter for my own work day to day? Especially if you have some decision-making power in your organizations, there's a few things that you could be doing. From least complicated to most, left to right. So you could do basic trainings where you just try the design process, kind of do a little bit of what the design process is and a hands-on application in 2 hours or 3 hours to get a feel of if you like this way of working or what kind of problems in your organization it could apply to. A little more complicated is actually trying to dedicate 5 days or even 2 days to a sprint where you bring your clients or your users together with your own group and you try to solve an actual problem in a very quick way using this process. A little more complicated is to do a full-on innovation track, so whether it's an ideas competition or like a 4-month or a 6-month dedicated let's solve this problem using innovation methodologies. Or the big kahuna is building a lab of your own. So making a dedicated space, time, staffing, budget. And I'm happy to talk to you afterwards about specific examples of who's doing what in the legal sphere on these. If you're more of a solo person, meaning you don't have time and budget or authority to run the things I just mentioned, here are small ways that you could change how you work to be a little more designerly. First is just to reflect on the different work product that you create, whether it's emails you send, memos you write, websites that you put up, and think who is your audience and how do they like to receive information? How do I make any of these things more clear, more usable, more user-friendly? Think about drawing, thinking about images. It's just a universal principle that people will pay more attention to a picture than to a block of words. So how do you use images more? Mapping out processes. This is great whether you're planning a class, you run a legal services clinic, or you run a law firm. Thinking about the kind of touch points in a flow. Talking, just even talking to your clients, your coworkers, your users about what they like, what they don't like. Thinking about how you can prototype, how you can draw out your ideas, get tests, run quick feedback sessions, and how you can get more designers and technologists in your life. Who do you know who actually can build stuff in better ways than lawyers can, and how do you get them to work with you on the problems you care about? One last thing, a plug I'll make, is with a bunch of my colleagues from Finland and Italy, we're setting up an international network of people who are working this way called the Legal Design Alliance. You can go to the website legaldesignalliance.org and sign up if you're interested. It's a kind of a group that's trying to make legal design more of a research field as well as how to collaborate better across borders. So welcome, come join us, legaldesignalliance.org. And with that, I'll say thank you. I'm over time. So I'm done. Thank you. Any questions? I don't want to keep people too long. Feel free to leave if you want to leave. But who has any questions? Yeah.
You had a slide up there before that said our hair is on fire, so it's time to start designing. Now, that's not such a big deal for someone who doesn't have hair. They don't have as much incentive, right? So my point is this: how do you incentivize the the need for innovation for particularly public institutions that can probably get away with being a bit more moribund than some other elements of society or business, let's say, that's perhaps got much more of an incentive to be disruptive and have competitive advantage. So what's your reflection on provoking public institutions particularly to get into the Innovation Act?
So I think after I spent the first 2 years of my lab trying to have kind of that pitch of why, especially court leaders, whether judges or executives in our judicial council, should be working this way. And oftentimes in the abstract, it's very hard to get them to prioritize something when they're in a scarcity mindset or they're in a everything's okay mindset. We're a public institution. We don't need to care about customers in the same way as a for-profit would. So my strategy has been to go where the problems are and where there's problem owners who are living that day-to-day of pain, dysfunction. So whether it's a judge whose whole docket is self-represented litigants in guardianship cases in probate court, and who feels either their own pain of dealing with a process that was not meant for people without lawyers, and then having to figure out how to operate a courtroom in that environment, or who feel that empathy for all these people who they can see are not getting fair outcomes because of the way the process is set up. And then letting them, or figuring out how we can be of service to their own, the problems that they see and the opportunities that they see. So I'm very much starting off with any public agency with discrete problems on the ground with problem owners who care about it tremendously. And then they can often build the internal advocacy and internal autonomy to get more attention and more funding. Because I find the best way to get on agenda is to have a working prototype or a working pilot that then the court could benefit with great, with that kind of innovation halo of look what's happened inside this particular county, or look what's happened that they can then get a grant from the governor to accelerate it. But going and especially pitching at the top level was a total dead end for me. It's changed a little bit now that the legislature and governor have put more of an innovation mandate on the courts. Now they're looking particularly for any product that can help, or project that they can put as a line item to say that we are being innovative. But without that pressure, it's trying to find the problem owners. We're at time. Okay. Well, I'm around if you want to chat. Thanks so much for your attention. I appreciate it.
Well, I'm Gary Cazalet, and I just wanted to thank Margaret for coming all of the way for a week. She arrived yesterday morning, which is even more remarkable for the performance that she's done. The fact that she's also going to be teaching in my class tomorrow, giving a faculty seminar at lunchtime. She's going to be working with a law firm on Thursday and doing a half-day workshop on Friday. That's a work ethic, isn't it? That's really extraordinary. So thank you so much for the talk. It's a really exciting time to be a lawyer, I think, and you're showing it, my students see it, and that was a talk that was really inspiring. Often one comes to talks and I can feel people yawning in the audience, and this time you could feel a rapt attention. So I really appreciate all that you've given. We're going to see a lot more of Margaret, you can be sure of it. Go onto her website, that's exciting, or her numbers of websites that she's got. I don't know how, given that she's got 2 children as well, that she manages to do all of the things that she does. So please accept this small gift from the law school.
Thank you.
And thank you for coming out.
Thanks,
and
Gary.
thank you.